Hello, everybody. I am Lisa, and I am going to be talking to you about estate planning. And estate planning is something that we rarely think about. It's something that we usually put at the back of our minds and think, you know what, we'll get to it later. We'll get to it later. The problem is that sometimes later doesn't come for some of us. I will tell you, I'll tell you one of my own personal experiences during the slideshow presentation. But for now, I'm going to be sharing a slideshow with you so you can get some more information on estate planning. And we hope you find this information helpful. And if you have any questions, please contact us. Thank you very much. Okay, so let's see. I am going to, first of all, this is actually, I'm not sharing my screen yet. So just give me 1 second. I'm going to share my screen with you. Oh, actually, I am sharing my screen with you. Okay, so we're going to start. This is our information. This is the law office of Lisa Uresti, PLLC, and I am Lisa. I'm presenting. And today we're going to discover how to plan for your life as you age. And the goal of our law firm is we help families protect their spouses, their kids, and property by planning for their future. And our website is at the bottom, and our phone number and our email. So we hope you find this information helpful. Now, you may be wondering, is this seminar even for me? Well, it is for you if you are frustrated with all of the information and confusion that's out there. Are you worried about leaving a mess behind for your kids? Then it's for you. Are you worried about skilled nursing homes and losing your life savings to long-term care costs and nursing homes? Then it's for you. Are you worried about protecting your assets from your immature kids or young kids after you're gone? Are you worried about the divorce of a child? Because some of us don't want our son's wife to get all of our money. And not me, my son is only 6, but some of us. And are you interested in making sure that what you want will happen if you pass away, become incapacitated, or if you need skilled nursing home? If any of you answered yes to these questions, then this seminar is for you. All right, so how many of you have a will, any type of estate plan? Well, you probably are with the rest of us. Only 34% of Americans have an estate plan. And an estate plan can mean a simple will, a trust, an asset protection trust, a ladybird deed, anything that you have done to plan for your estate and how you want to pass your assets when you die. It's only 34%. Okay. That means that 66% of us, which is way more than the majority, do not have any type of estate plan. We have no plan. We work our whole lives and we save and we work and we pay for vacations and we make sure our kids are okay and our spouses are okay. But yeah, we don't have a plan for when we die. What's going to happen to your money? Could the state take your house? Could the taxes on your home accumulate and nobody could pay for them? Well, we want you guys to get a plan. Okay. But before you sit here and listen to me for several minutes, you may be wondering, who is Lisa? Okay. So first of all, I'm an attorney. I grew up in San Antonio, Texas, and I graduated from South San Antonio High School. And then I went to UT in Austin, and I got my law degree from the University of Wisconsin. I was raised to have a strong work ethic. Okay. My mom worked very hard in our house. She also worked jobs outside of the home. My dad worked very hard. He was a firefighter and he was always studying to get promoted. He eventually became a district fire chief, and he showed us the value of having a strong work ethic. So I work hard for my clients as well. It's what I learned to do. And I always work to fight for my clients. And my form of fighting for my clients is to make sure that they are protected. Okay, their assets are protected. Right. So I have a personal experience. I have several personal experiences, but one that stands out is that my grandpa, he got dementia several years ago. And he started forgetting who people were, and dementia, it just, so many elderly people suffer from dementia. And there's a very high likelihood that either you or somebody you know will suffer from dementia, either directly or indirectly. But when my grandpa got dementia, he could no longer do an estate plan because you have to have the capacity to do an estate plan. Well, so when he died, he didn't have a valid will. He had a will, but it wasn't really done correctly. Okay. So we had to probate it. And when we had to probate it, it just cost so much money. Okay. Mind you, I gave my family a discount, but had they not had me, they were going to spend thousands and thousands and thousands of dollars to probate that will that wasn't done correctly. It didn't have witnesses. It wasn't self-proved, right? And so we had to get all of the several children that he had to sign a waiver saying that they're okay with it. And it's not easy to get a lot of people to agree on anything. So that experience, that really shaped what I wanted to do for my clients. I want your family to be able to grieve for you without having to worry about who's going to get mom's house, who's going to get dad's house. Oh my gosh, how are we going to split this? Oh, who's going to pay the taxes? Oh my gosh, he has that one truck and we forgot to change the name, right? So I want you to be able to do this and just grieve. You just want to be able to grieve for somebody when they die, okay? And I'm a trustworthy attorney. I do everything in the best interest of my clients, okay? I am my client's fiduciary, and I take that with great responsibility. And then we have our team. I have 2 legal assistants. I have some contract paralegals, and we're currently looking for contract attorneys. So we've been growing. Actually, it started with just me, and I was doing everything. And but we've been growing and been able to help more clients. So now let's tell you what you're going to learn today. You're going to learn, and just so you know, I have a family just like you, right? This is my family, and I want to make sure they're protected as well. If I die, I want to make sure that my kids can go on and continue through school, and they have somebody, we can pay somebody to help them. And so this is my family, and this is why I do what I do, because I want to make sure that they're protected, and I want to make sure your family's protected. So what will you learn? You're going to have an understanding of estate planning by the time the seminar is over. You're going to understand about medical care decisions and how they're handled. And you're going to have an understanding of how to protect your assets. Okay? We're going to talk about the 3 components of estate planning, and you're going to walk away here with some peace of mind. Okay. All right. So there's 3 time periods that we're going to kind of go over today. And in those 3 time periods, there's the one where you're alive and you're well and you're going on vacation, you're in control, you have access to all of your assets, and you really just take things for granted. But then there's another time period when you're incapacitated, and that would really cover dementia or Alzheimer's, or maybe you had a stroke, but you're not in control. But who's in control? Do you even know? Do you get to decide? Who's in control of you? Have you thought about that? Who's in control of your stuff? Who has access to your stuff? Whose rules govern? Well, that's something we need to think about. Or there's a part when you're deceased. And some people may have the opinion of, I'm dead, I don't care what happens. But some of us, like me, I want to know who's in control. Do you know who's going to be in control of all of your belongings when you die? I mean, you worked hard to get all your belongings, right? You saved all those boxes of your kids' homework. You saved your trophies and you saved money and you saved a car and you paid for your house. You pay taxes on your house and you've done all these things. So now who's in control? I want to know who's in control. Who has access to your belongings and your assets and your house and your car and your bank accounts? Can anybody even access your bank accounts? Whose rules govern? The state's rules? Your rules? The court's rules? Whose rules govern? And when you're deceased, do you need a will or do you need a trust? All right, well, let's get working. So we're going to do this. We're going to start off with some examples of some made up clients. Not real, absolutely made up. Okay, so first we're going to meet Mark and Jane. All right, so Mark and Jane are getting older and they're worried if they're going to have enough money to pay for their care. Oh, I'm going to make this a slideshow. So Mark and Jane, as you can tell, they're in good health, but they don't want to wipe out their life savings if they eventually need help. And see, their neighbor has Alzheimer's, and their neighbor spent everything, went through their whole life savings dealing with Alzheimer's. All right. Okay. So here's another Mark and Jane, right? And our point here is that these scenarios go across the board, right? Across the state of Texas, across our city, across your family. Here's another one where Mark is 70 and Jane is 68. They have 4 children. They have Jennifer. Jennifer's 44. She's an engineer, right? Jason is a manager at HEB, right? We've all seen Jason. Scott is a son that has some substance abuse problems. And then there's their son, Larry. And Larry has autism. And Larry cannot function without the help of somebody. Okay. Now, some of their assets that they have a $400,000 house in San Antonio. They don't pay taxes right now. Their taxes are deferred because they're over 65, right? You see 68 and 70. And we're going to talk about deferring your taxes later, but they don't just go away. Taxes are not just gone. They just don't have to pay. Mark and Jane don't have to pay their taxes right now. But they're accumulating, guys. Don't think they go away. They also own a $250,000 rental home in San Antonio. They have $100,000 in retirement, and they have $50,000 cash in the bank. They have 2 cars, and they live off of Social Security and retirement, and then retirement account. All right, that may sound familiar. I mean, this is not a unique circumstance. Okay, so those are 2 people that we're going to talk about, and we're going to talk about 3 key estate planning strategies. Okay, and these estate planning strategies, we're going to call them the rebound method. Right here. This is the rebound method. You guys see the Spurs getting the rebound. The reason we call it the rebound method is because everybody is like fighting for that ball. Like, give me that ball, right? And it's kind of like your family, like, give me that house, give me that money, right? So that's the rebound method, right? Then you got the basket method. The basket method is what we're gonna call, like, you get a little basket, and everything that you own gets put in the basket, right? And you can take it out. You gotta open it up and take it out, right? Still secure, right? But then there's the piggy bank method, right? And everybody knows you gotta break a piggy bank. Some of those piggy banks are hard, so they're a little more secure basket. You can just open, right? But then we have the piggy bank method. We're gonna explain what every method is, but those are the methods we're gonna talk about. All right, so we got the rebound method. That's what we call our will planning method, right? That's what most attorneys are going to offer you. Oh, you need a will. You need a will. You need a will. Everybody needs a will. And a will is great to have. It's better than nothing by all means, right? So we call that your last will and testament. Usually what attorneys will prepare with that, including us, we'll do a financial power of attorney, healthcare power of attorney with a living will, and a HIPAA authorization. All right. So power of attorneys, any power of attorney, no matter what anyone tells you, is only good while you are alive. Once you die, right? So if I have a power of attorney, I am my husband's agent for his power of attorney. If my husband dies, I automatically lose that right. Because the entire definition, it says you are the agent while somebody is living. Then you have your last will and testament. Okay. So a lot of these rely on your financial beneficiary designations, right? So you need to make sure that you have beneficiaries on your bank. Sometimes people say, oh, I do, don't worry. And then we find out, well, one of your accounts, the largest one, didn't have a beneficiary. When you die, you don't really have a lot of control with a will. Right? You get to say, oh, my house goes to, Mark, but you don't get to decide. You may get to say that Mark gets your bank account, the money in your bank account, but you don't get to decide at what age he gets it. You don't have a lot of control. It's either it's basically all or nothing. Okay. Death equals transfer. Once you die, that person, beneficiary, gets your assets. And it can delay the sale of real estate. And that becomes a problem when taxes, like we talked about earlier, have been deferred. Because if you're 65 and you defer taxes for 15 years before you die, you have 15 years of accumulated taxes. That could be $20,000. It could be $100,000. If those taxes aren't paid off after 180 days, guess what? Penalties, interest, all of that's going to occur. Yeah, that person who you left your house to now owes $40,000, $50,000, $200,000 in taxes. They're not going to get very much equity in that house. There's also ancillary administration, and that could happen if you own a house in another state. They don't have to accept the orders that our judges give us in Texas, because there might be different methods in different states. And I will tell you, it's fairly simple to probate a will in Texas, but it's not fairly simple to probate a will in other states. So then you'd have to pay an attorney in Texas and pay an attorney in another state if you had any property in another state, which it could happen. All right, so that's the rebound method. It's a will, better than having nothing, but it could lead to some fighting. Wills go through probate. Well, what's probate? It's a legal proceeding. It could take 9 months or more. The control lies within the judge. The judge gets to tell you if the person who you chose to be executor, the judge gets to say if that person's executor. But let's just say that somewhere the executor did something that the judge doesn't like. Maybe the executor's thought to be a bad person by other people, not by you. You trust that person. That's why you named that person the executor. The judge can say, no, that person can't be the executor. I'm going to name my own executor. Right? It doesn't always happen, but it could. Anything you put in your will, it's public. Not everybody thinks about that. But so let's just say you have 5 kids, but you don't want Joey to know that you left Sarah the house. Or maybe Joey didn't even know that you had $10,000 in your bank account that you're going to leave to Sarah. Well, it's public. Maybe you have property that your sisters don't know about, and you don't want them to know that you had money saved up, because remember, you didn't lend them that $500 the day they asked. They're going to know. They might be a little upset. It's also very expensive to go through probate. I'll tell you, with us, I mean, we don't see less than a $3,500 spent on probate. And I would say that's pretty reasonable. There's a lot of court filing fees and attorney's fees and just a lot of fees in general. And then your kids would fight because it's public. You could have kids fighting, siblings fighting. Oh, mom didn't leave me this. Mom didn't leave me that. Those are some issues with probate. And here's a rebound playing out. Okay, remember Mark and Jane? When Mark passes, and then, he has to probate his will. And so Jane's going to come to me and Jane's going to say, Lisa, I need to hire you, right? And I'm going to say, okay, Jane, it's going to be $3,500. Jane is going to spend, $3,500. She's going to wait months. We're going to probate the will. And then 2 years later, Jane is going to pass, right? Well, guess what? Now that child, I'm trying to find their name. Jennifer, remember Jennifer, the engineer? Jennifer's going to come to me and Jennifer's say, Lisa, I need to probate mom's will. And I'm going to say, okay, Jennifer, it's another $4,500. I mean, $3,500 or $45. Who knows? I don't know. So now they paid $7,000. And then we're going to have to deal with the car titles. And we're going to have to go transfer. And then we're going to have to deal with the bank accounts. Okay, well, maybe some of those bank accounts had a beneficiary and mom forgot to take it out and mom didn't change the beneficiary, right? But here's the other problem. The stuff that may not, but if there's a beneficiary on everything, okay? So let's just say your bank accounts, your 401k, your retirement. Let's just say those all have beneficiaries. And let's just say, let's go back to that side, that you had 4 kids as your beneficiary. Because a lot of times we just put all of our kids, right? So you had bank accounts, 401k, retirement, all as beneficiaries. Well, guess what? None of that falls into your will because it's only assets that don't have a beneficiary. So what do we have for your will? A car and a house? So basically you paid, in essence, $7,000 to probate, to get rid of the house and to divvy up the house and the car title. Well, what's going to happen? What's going to happen to that retirement? 401k bank accounts. Remember the son that has a substance abuse problem? You're just going to give him $50,000 like that? Is he going to spend it on drugs? I mean, he might not, but a lot of people that have substance abuse problems will spend all their money on drugs. You don't get any control here. Now, what if Mark and or Jane need long-term care, right? So we're going to do the rebound method with long-term care. So if one of them needs to go into a nursing home, what are they going to do? Because remember, they just have the will. We're doing the rebound method. They can self-fund, so they can pay. Remember that they had some money. Remember this, they had $400,000. They had home, the rental home, whatever money they get from that rental home, the retirement, and the cash in the bank. So they can pay. But I'm not sure if you guys know, but nursing homes cost anywhere from $6,000 to $10,000 a month. And I would say an average of a license, like a nursing home, could cost around $9,000 a month. I mean, with the money that Mark and Jane have saved up, I don't think they're going to be able to stay in a nursing home for that long. Well, they can spend down all their assets to qualify for Medicaid. What that means, what are they going to do? They're going to sell the rental home? So let's talk about Medicaid rules. The house that they have will be exempt because remember, their house was worth $400,000. Medicaid will exempt up to $688,000 of a home in Texas. So they won't even count it. But the rental income, that's countable. Remember, it's valued at $250,000. So Medicaid can say, nah, you have $250,000. You don't need our help. The retirement and cash countable is $200,000. Well, we need to get below $2,000 and or for one person, or up to $148,000 accountable if you're married. So we're going to have to get that $450,000 of countable assets. And I'm not counting the cars and I'm not counting all that stuff under 148. What are we going to do? I guess we could spend it all, but then there's a 5-year look back period. Guys, any money you spend 5 years from the date you apply for Medicaid, Medicaid's still going to count all that. So now you're going to wait 5 years? I mean, yes, there's some things we can do to spend down and qualify for Medicaid. You could buy a funeral care plan, but you're not going to find a funeral care plan for $200,000. I mean, I guess, but like, do you want to spend $200,000 on a funeral plan anyway? Now, let's just say you spend down all your money. right? We got to get under 148,000. But that home you have, that home you work so hard for, it could get a Medicaid lien. Medicaid's going to come back and they're going to say, hey, you asked for Medicaid. I paid for you. I gave you, I paid all your nursing home costs. But look, you owe us that money back. Well, guess what? You wanted to leave Jennifer the house or Mark the house. They're not going to get it. So Mark and Jane named Jennifer as their executor, right? Let's do the rebound playing out again. And the 4 kids as equal beneficiaries in the will. They list the 4 kids as a quarter beneficiary on their retirement and cash accounts as well. If either becomes incapacitated, the other can act on his or her behalf for financial or medical decisions, right? And then they name each other as primary beneficiaries and their kids as secondary contingents. So that's how it really happens. But we've talked about, like, this is what on paper it looks like. It looks fine. It looks great. But remember, we just talked about earlier what's really going to happen? This is Mark and Jane, guys. This is not some unique couple, right? I mean, their house may be more, it may be worth more than yours, and it may be worth less than yours. You may not have a rental home. You may think, oh, I'll never qualify for Medicaid, so it doesn't matter. But you guys are not thinking about regular Medicaid. We're not thinking about the Medicaid you qualify for because you don't make any money or you're considered quote unquote poor. No, I'm talking about Medicaid for long-term planning. The only thing that exists for long-term planning, like to put us, like if we need to stay in a nursing home, is Medicaid. Medicare isn't long-term planning. It's like a 30 days, like they'll pay for a stay and then you got to requalify. It's only Medicaid. And probably most of you that think you cannot qualify for Medicaid actually can. You just need to know the rules, and the rules are not meant for you to understand. They're meant for me to understand because I study them, and that's what we do. All right, and just so you see, this is the cost of long-term care. We talked about how you pay for long-term care. This is middle-class America's biggest financial threat. You can stay at home. That varies who's going to take care of you. Independent living, $25 a month. Personal care, we have somebody coming over, helping out, $5,500 a month. Nursing home, $10,732 is a pretty average cost. Guys, keep that in mind. How many of us can afford to pay this? That's insane. So remember, that is what you would have to deal with if you have a rebound method, right? With any of our methods, you're going to have to deal with this stuff. But just think about the cost and how am I going to pay for this and how am I going to do this, okay? Let's talk about our next method. Let's talk about the basket method. Okay. This is, I would say, a very suitable method for a lot of people. Not for everybody, a lot of people. And what a basket method includes is it's revocable trust planning. Revocable, it means you can revoke it at any time, right? So it's basically everything that the will plan offers you. And you can do a joint or an individual revocable trust. We don't do joint wills, just so you know, but we can do a joint trust. And there are different reasons for that. But you can do like a family trust. You can implement rules. You can have control. There's conditional thinking, and what that means is if you do this, then you get this money. For example, if you go to college, I will pay for 4 years of your university tuition, right? But if you don't go to college, I'm not paying for that. It is what it is, right? So you have control. Probate's avoided. You can avoid probate. Not always. Sometimes you have a trust inside of a will, but a lot of times you avoid probate. So let's just say this revocable trust planning method may cost a little more upfront, but it's going to save you. Remember that $3,500 where you paid for probate when you just had the will, it's going to save you that amount. It's going to save your family waiting months. It's going to protect your assets against minors, immaturity, drug abuse, special needs considerations. It's going to allow you to immediately sell real estate. Like the day after you die, basically your trustee could go in and sell real estate if that's what you if that's the rule you implemented in your trust. You can contribute to, or you can withdraw your assets whenever you want from a revocable trust, from the basket method. So remember, the basket has all of your items right here in this little basket, and it'll open up, and you can take it out, or you can put it in. And you can take it out, or you can put it in. Okay. It eliminates that ancillary administration. So remember, we talked about if you have a property in another state, if you have a trust, you're not going to have to pay to do another probate in another state. And you can fund it during your life, or you can fund it when you die. Okay. And here's an example of how you fund it during your life. So, for example, your house right now is titled, like, I don't even know what my house is titled under Lisa and Kevin. Okay, that's my husband. But if with our trust, we do have a trust, but we have not funded it with our house yet. But we could fund it with our house and we would retitle our home and say the family trust of Lisa and Kevin. So now my trust owns the home. I mean, it's not really the basket owns the home, but when I die, or even today, that house is the trust. I am named the trustee. It's still mine. I still get all my exemptions, my over 65 exemption, my homestead exemption, my disability exemption, my veteran exemption, everything that I could get, I still get it, because in the trust, we have wording that says we still get all of our exemptions. Just make sure your attorney puts that in there. You also, now, the one thing is that the revocable trust planning does not offer you is you do not get protection while you're alive or from Medicaid and nursing claims after death. So again, you're not going to be able to qualify for Medicaid. This basket method is not going to help you, but it'll still protect a lot. It'll give you that control. It'll allow for all of these things that are listed there on the slide. Okay. Now let's play out the basket method. All right. Remember, Mark and Jane. Mark and Jane, they're going to deed their house and their rental to the trust. Okay. They're going to do that today. So now the house says in the family, it's titled in the family, to the family trust of Mark and Jane. Then they're going to name their beneficiaries, all of their bank accounts, 401k, retirement plans, all of their assets. Instead of saying, oh, we're giving 1/4 to all of our kids, what Mark and Jane are really going to do is they're going to name the family trust as their beneficiary. So when they die, all that money, that $100,000, it's going to go into that basket. Okay. The trust has the kids named as beneficiaries. Okay. So that's what they did. They named all of their kids as beneficiaries. But Scott and Larry's interest has more structure and control. Remember, Scott and Larry, one of them is a substance abuser and one of them has autism. So with that structure, they're going to put them there. They can't use drugs if they get that. If you don't have to give them money if they're on drugs. And for the one who has autism, they're going to tell, maybe Jennifer is administering that trust. They're going to tell Jennifer, put it in a special needs trust, right? Because remember this, Larry has autism. Put it in a special needs trust for Larry. And Jennifer is going to do that. And all of that $100,000 that Larry inherited from his parents is going to go in a special needs trust. Because you know what happens when you have a special need and you get $100,000, you run the risk of losing your disability benefits. No, we don't want our kids to lose their disability benefits. But if you put it in a special needs trust, you will protect their benefits. So now you've protected Larry and you've protected Scott from using all his money on drugs. All right. Now, Scott and Larry's interests will be administered by Jennifer till they're 55. And then Jennifer can say, okay, I'm done. And you may be wondering, what if Jennifer doesn't want to do that? Well, you've already talked to Jennifer about that. Jennifer can be compensated up to, usually I would say a reasonable percentage in Texas, about 1%. She can be compensated for all the money she's she's having to handle and work with. But Jennifer's just awesome. Jennifer is a great child, and you know, a lot of us have that one child that we know is going to get stuff done. So your basket method playing out, you have control, you have structure, you have protection for your beneficiaries, but not for Mary and John. And actually, Mary and John, and I should say Mark and Jane, sorry, but Mark and Jane, Mary and John, you know, there's no protection for them. Remember, because there's still this trust is not going to help them qualify for Medicaid. You just remember that they're not the ones getting the protection. All right, again, that's Mark and Jane. All right, so then here you go. We are going to now talk about we already actually talked about this, so we're not going to talk about this. This was just in case. All right. So again, long-term care costs, guys. You're still going to have those issues with long-term care costs. Okay, so now let's talk about the piggy bank method. All right. So the piggy bank method is going to be the method that we discuss that is more of an asset protection trust planning. And that is where basically it is what it says it is. It's going to protect your assets no matter what, right? Well, usually no matter what. And this is what we use here is an irrevocable protection trust plan. Now, just so you know, not everybody's ready for this. And we don't use it for everybody. But so we look at our clients on an individual basis and we decide what's best for them. And we'll tell them, these are the options. This is what we think is good. These are the pros and cons to each one, right? We don't tell our clients what to do. Our clients tell us what they want to do. Okay. Now we have protection trust planning. And it's the same benefits of the basket. Remember all those protections that the basket method offered? Revocable trust planning, but we have additional protections. And the reason is because you have creditor protection while you're alive. Okay. So anything that's in that asset protection trust, that's protected from Medicaid and from nursing homes. So remember, let's go back here. Remember how Mark and Jane had that rental home, and earlier we said it was a countable resource, and Medicaid was going to say, no, you have a $250,000 home. Well, it won't be counted, right? You can appoint someone to have access if needed, right? And so the 5-year look back, the gift look back, it still applies, right? If we put it, but if you do it now, the 5-year gift look back period may not apply for certain assets. So we're going to talk about it. Now, piggy bank method playing out. All right. Mary and John, you know what? We're going to stick with the same names. We're going to say Mark and Jane. Mark and Jane, they're going to move their homestead and their rental into that protection trust, right? So now it's still called the Mary and John or Mark and Jane Protection Trust. And they're going to put that $50,000 money market into the protection trust. They're going to appoint Jennifer as a trustee and the lifetime beneficiary, right? But just to be clear, what this means is if Jennifer's the lifetime beneficiary, Mark and John or Mary and John, they no longer are the beneficiaries of their own trust. So you really they're going to have to rely that Jennifer is going to give them money when they need it, right? Now, we can't make Jennifer give them money. They're going to have to rely on it. So that lifetime beneficiary has got to be someone that they really trust, right? And we can't have some secret agreement that, Jennifer, we're going to do it this way so you can give us money on the side, right? But we all have that kid. I mean, most of us have that kid that's going to do the right thing, right? And Jennifer is going to say, hey, you know what, Mom? Let me pay for your doctor's appointments. Let me do this, right? So Mary and John are still going to live off of Social Security and retirement assets and maintain their residence in the home and use of their rental home, just like they always have done. And then John and Mary, let's just say they need long-term care skilled nursing, right? And how are they going to qualify? Well, guess what? They don't have that $250,000 rental home, and they don't have that $50,000 cash in the bank countable, right? That's not countable. The 250 and the 50 are not countable. So what that is that just helped them relieve $300,000. The only things that they had that were countable in this slide were the 250 rental home, the 100,000 retirement, the $50,000 cash in the bank. That was for that was $400. Well, we just helped them get rid of $300,000 as countable assets. So now we have $100,000 countable, $100,000 countable. That's it. Okay. So guess what? How are they going to deal with that? Remember one thing. Okay. Let me go back. Sorry. Remember this. Must get below $2,000 or up to $148,620 countable if married. So look, guess what? We're going to get that $100,000, and let's just say that it was John who needed the money. We're going to put the $100,000 in Mary's name, and she's going to live off that retirement, and John is going to go qualify for Medicaid, and he's going to live in a nursing home that would have cost him $10,000 a month, and he's going to live there for whatever Medicaid says that he owes. Medicaid may say, well, your contribution, John, is $1,000 a month, or maybe it's $600, or maybe it's $1,200, or whatever it is. But that sure is a heck of a lot better than $10,000 a month. And they don't have to go through their life savings because they still kept their rental home, they still kept the cash in the bank, and they still have that retirement money that Mary can live off of. Well, after John and Mary both pass, that asset protection trust will transfer to the kids according to John and Mary's wishes. Guess what? Again, this is not for everybody, because I wouldn't do one of these right now. I am not planning to qualify for Medicaid. I usually don't even bring these up unless people are over 65, and unless there's special circumstances. But I'm 43, so I wouldn't think about doing this yet. But I do have it in the back of my mind for when I'm getting older. And I do have it in the back of my mind for my parents, and for you, and for your parents, and for your families. Now, what if Mark and Jane or Mary and John had used the rebounder basket method? Well, without the protection trust, let me tell you how this would have played out. If they would have just used the rebounder basket method in order to qualify and still needed Medicaid, right? So let's just say Mary needs to get long-term care. She got sick. She has dementia. She needs to go stay in a nursing home. She's suffering from some heart problems. They're going to have to sell that rental home. That's countable asset. And guess what? They're going to have to use that money, $250,000, and spend it down. Then they're going to spend down all their cash and investments until they get to that $148,000. But remember, everything they owned that was countable was about $400,000. So they're basically going to have to spend, roughly $250,000. So they basically have to sell the rental home. And then they got to spend all that money down, not just sell it, spend it all. And then not only that, but Medicaid's going to put a lien against their primary homestead. That homestead. Remember, guys, that homestead, everybody in America works for a home. Once you buy a home, you've considered yourself like, good. I have my home, I'm good, right? I don't have to live in an apartment anymore. I don't have to rent anymore. We work so hard. But Medicaid's going to take it. Because remember, it's not accountable, but it is subject to Medicaid enforcement. And kids are going to pay that lien after they sell the house. So nothing was protected, right? Or they're going to have to self-fund the nursing home with that $250,000 from the rental home. But guys, that could have been avoided. I mean, and maybe they get 2 years out of the nursing home. Well, you know what? Is that enough? What if they need more than 2 years? I don't know. Hard to say. And then they're going to have to qualify for Medicaid anyway and still get a lien on their home, right? They can cash out assets or buy a long-term care policy, but most of us don't have long-term care policy because it's very expensive. Again, here are the costs. I just keep bringing these up to y'all so y'all know. So recap. We talked about a rebound method. It's quick. It's straightforward. Hey, if you're gonna do anything and you don't have, let's just say you don't have a lot of money and you just like, I want to do something in case I die today. And let's just say you're 50 and I don't have, I don't want to protect my assets right now because I'm fine. I'm not sick. Whatever your reasons are. I don't care about the future. I don't care if I had to pay for Medicaid. Maybe that's your attitude. At least get a will. But this is a rebound method, having a will. It's the lowest investment. It's the least involved. You're going to go to your attorney. I want to give everything to my sister. If you have no need for control or protection and you don't want to protect your assets, then this is the plan. If you have one property or less, or you're renting, then this is the plan. Rebound method is good if you're fine with real estate delays. A rebound method is good if you have no reservations or concern for long-term care or how beneficiaries receive their assets. So no control again. And the rebound method is good if you have powers of attorneys and living will, and they'll protect your wishes during your incapacity. Okay. So if you're sure that power of attorney, that agent that you name, your son is going to protect your bank account and protect your car and your house and pay the taxes, and just by being your power of attorney while you're alive, then this is the method for you. And just remember that this must go through probate. All right. Next is going to be a recap on the basket method. The basket method allows you to sell real estate without any delay. It's going to eliminate out-of-county and out-of-state real estate issues. Remember, you don't have to do any, there's no ancillary probate cost. It allows you to have control or structure in the way that your kids or any beneficiaries receive money. You can do an if, then this. So if you go to school, I will pay for your tuition. If you live in the house, I will pay the taxes, whatever conditions you want. If you have a child, I will pay for their private school. Consistent rules for all assets. You can make them very consistent. It's conditional logic. If this, then that. Protect assets for beneficiaries, but not asset protection. So it protects your assets for your beneficiaries, right? But it does not protect, it's not asset protection for you. It's not going to protect your assets from helping you qualify for Medicaid or from Medicaid coming and taking. And this does not protect against Medicaid liens, and it does not protect you from having to spend down. All right. Next, recap, piggy bank method. Piggy bank method is the same benefit of the basket revocable trust planning, but it protects certain assets from creditors while you're alive. Remember your rental, your house, bank accounts. It protects you having to spend down all of your protected assets. If you need Medicaid, you're not going to have to spend down because we've already taken care of that. It protects your assets from Medicaid enforcement liens. Remember that homestead? Medicaid's not going to be able to put a lien on it. It ensures your assets in trust will go to the intended heirs no matter what. And see, nobody's going to be able to fight about it. And it allows a designated person, Jennifer, to access funds if needed. So if you need money, Jennifer can give them to you if she wants. And she's that really, really nice daughter that is going to do anything for you because you worked hard to put her through college. Remember, she's an engineer. All right. So again, payment options for long-term care planning. You pay. That's it. You got it on the left side over here. Or you get the government to pay through Medicare, but that's not long-term. It's only for 30 days. Medicaid, crazy rules, right? Only attorneys really understand them. And or you can get the VA. If you qualify for the VA, this seminar is not about VA, but we can help you. And sorry, I'm noticing this is misspelled, but the service requirements or the asset income requirements are there for the VA. So call us if you have VA and we can help you with that. And long-term care, or you get long-term care insurance. And again, it's very expensive. And I think it gets older as you age. But if that's something that you want help with, we can help you. We can hook you up with somebody. All right. Again, Medicaid basis. Remember, countable assets, income cap $2,742. But you can only have countable assets for $2,000. You get about $60 a month. Married applicant, resource countable, right? So the income is for when you have two married couple, the income is capped at $148,620. And then that countable asset cap is still at $2,000. All right. So again, income. What can you be getting? $2,742 for the applicant, $5,484 if both spouses are applying. All right. So you can still be making that. You can still be earning income. So far, what have you discovered? You discovered there's a rebound, a basket, and a piggy bank method. And there's no right answer. Everything depends on you. Depends on how much control you want and how much protection you want for your kids and for yourself. And Medicaid eligibility planning. You know, some of you probably are like, oh, I don't qualify for Medicaid. That's not necessarily true. Well, maybe you've been denied. Or maybe you didn't apply correctly. So have you been told no? 10%. 50% want to protect their assets. And 70% of you, it may not be too late. Okay, even if you've been told no. So the key point to this entire seminar is to teach you that you can protect yourself, your family, and your life savings. So if you do want help, we would love to be able to help you. We love to help our clients. We love to help you protect your assets. We love to just to make this a seamless process. Again, you're going to have to work. It's not going to be like you're just going to come to me and I'm going to go to your bank and look for all your accounts and you're not going to have to give me any information. You're going to have to do a little bit of work. But so if you want us to help you, right, this is how we will do it. This is our process. So first we have a vision meeting, right? And that's where we'll meet with you. We'll talk, we'll get a little information, we'll understand your goals and your options. Okay. Then what we'll do is we'll have another meeting. We'll have a design meeting, right? You'll ask questions, you'll clarify options, you'll make a decision, and you'll obtain information we'll obtain information to start drafting. And then we're going to have a signing meeting. Okay. You're going to review your documents. You're going to sign your documents. You're going to create a funding plan. And then we're going to do maintenance, law changes, family changes, goal changes, health issues. Okay. So this is our process. There's a lot of stuff in between. Sometimes before the signing meeting, we'll have a meeting with you just to show you all the documents, make sure everything's spelled correctly so that we don't have to do any changes and we have everything ready. We set you up with some nice little portfolios and something that you can keep. And that's our process. And I will tell you that today only today, and it's only because we're doing our seminar, and we only do this once a month, and we only save so many spots, and we have them actually already reserved. We have 2 days of spots that we're going to use to do consultations for this seminar only. And because this is the first year that we've been doing these seminars, and we have been able to help so many people, and it's been great. And we've just really loved doing this lately. So we offered this last time, our last seminars, we're offering it again. And it's not going to be available tomorrow, only today. And you're going to make an appointment on our calendar. And it's going to be a Google Calendar, and you're going to pay $20. Okay. $20 is what you're going to pay. That's it. Normally our consultations run $250. Okay. No estate planning attorneys that I know charge $20 for a consultation, but it's only because of this seminar, right? We're going to do about no more than a 45-minute like initial meeting, understand your goals, and if we can help you, right? It's not, this is not where you're going to come in and bring all of your documents. This is just so we understand your goals and see if we can help you, and if we think that we're a good fit for you, and if you're a good fit for us. And if we're a good fit, then we're going to have those other meetings, right? But normally, even for this first meeting, we charge $250. But today, $20 if you book on our Google Calendar today, right? If you don't show up, we're going to donate that $20 to the Military Warrior Support Foundation. And it may be a little less than 20 because we get to charge a credit card fee, but whatever it is, if you pay with a credit card, we're going to donate that. So, I would act now. We don't have very many spots. I think I can't remember if we have like 8 spots, that 4 per day for 2 days. So what you're going to do is you're going to scan the QR code first. Okay. You're going to pay the $20, and it's just going to charge you. The QR code is already set up. So you're going to get out your phone, and you're going to go like this, and you're going to scan the QR code, and then you're going to go to the next slide, and you're going to scan the QR code again, and a Google Calendar is going to come up, and you're going to set an appointment. There's going to be 2 days. There's going to be, I think, 2 days, and you're going to make an appointment, and you're going to schedule a time with us. Okay. So, and if you don't see a time and you feel like you called, right after this meeting, please call us at 210-928-2701. 210-928-2701, and see if you can still get one of those 8 spots. All right. So thank you guys. I hope this information was helpful to you, and we look forward to seeing you soon. And I think that, and here is our information again. Our office is here in San Antonio. It's downtown. My email is here on the left-hand corner. Stephanie is one of my legal assistants. Her email is on the left-hand corner. And in our office, email is info@urestilegal.com. And we shared all that information at the beginning. So thank you for watching this seminar, and we hope you have a great day.